Hello viewers, in this lesson we shall try to understand the concept of legal maxims and also equitable maxims, which constitute a major chunk of legal language. Introduction. A legal maxim is an established principle or proposition. The Latin term, apparently a variant on maxima, is not to be found in Roman law with any meaning exactly analogous to that of a legal maxim in the medieval or modern sense of the word, but the treatise of many of the Roman jurists on regular definitions and sententia juris are in some measure collections of maxims. Most of the Latin maxims were developed in the medieval era in European countries that used Latin as their language for law and courts. It will be remembered that a maxim is a general principle and universally approved leading truth. Therefore, even the most elementary student cannot do better than store away in his memory some of the more important of these rules as a foundation for future study. At every law examination, questions are to be found that bear directly on one or other form of the principles contained in these maxims, and they are often quoted. The student is generally required to translate and explain their meaning and application. They are in fact equally important with leading cases. In this lesson, those maxims only have been selected which are constantly met with by the student and which he would do well to commit to memory. The explanations have been made as brief as possible, and for deeper research the student is referred to Broom's legal maxims or any other good source. Now, let us try to understand the advantages of understanding the legal maxims. Those who wish to follow successfully the law as a profession must remain students to the last, and the leading truths and time honored legal principles as defined by the maxims hereafter contained will ever serve alike as safe landmarks and sheet anchors in times of doubt and uncertainty. These legal maxims are not only useful to law students, but also researchers, lawyers, judges and administrators. It is said that one maxim conveys more than 1,000 words, as it explains clearly the well established legal proposition laid down and recognized the world over. A legal professional well acquainted with legal maxims always enjoys an edge over others, as his decisions would be in tune with the spirit of law and thorough justification. Famous legal maxims. Dear students, you may understand that there are hundreds of legal maxims which are mostly in Latin. They are relating to various branches of law and their interpretation. They cover law of torts, crimes, contracts, property, limitation, public policy, judicial interpretation and administrative law. It would not be possible to explain all the maxims in this lesson. I therefore will make an attempt in this lesson to explain some of the most popular legal maxims covering different fields of law. First maxim: e verbis legis non recidendum est. This is in Latin, which means that the words of the law must not be departed from. It is related to judicial interpretation as well as application of law. Acts of Parliament or state legislatures must be interpreted strictly according to the express letters of their respective clauses. Although in certain cases an equitable construction can be placed on the words, yet this principle is confined within certain limits, and a judge cannot, in favor of a presumable intention, depart from such words when, for anything that appears, the wording may correspond with the design of the legislature. Actio personalis moritur cum persona. It means that a personal action dies with the person. In actions of tort, that is civil wrong, this was formerly a general rule, but recently its application has been so generally narrowed that it probably affects only actions for libel and slander, which are part of the law of defamation. Compensation may, however, now be recovered by the relatives of a person negligently killed. Compensation may also be recovered in some cases of trespass. Actus non facit riem nisi mens seria. The meaning of this maxim is that the act itself does not make a man guilty unless his intention be so. There must be a vicious will or criminal intention or menseria as well as an unlawful act. Where one engaged in doing a lawful act without any wrongful intention unfortunately or inadvertently kills another person, the homicide is excusable, because in the instant case menseria is not found. This maxim is one of the important principles followed in criminal law all over the world. Audi alteram partem. This means hear the other side, that is, do not condemn a man unheard. This is one of the fundamental principles of the British Constitution and also the principles of natural justice. Contemporanea exposito est optima et fortissima in lege. The meaning of this maxim is that a contemporaneous interpretation is the best and strongest in law. In interpreting an old document or statute, consideration must be had for the intention and intended effect at the time of its execution, on the ground that the same were then best known and appreciated. Contractus ex turpi causa vel contra bonos mores nuis. A contract arising from a base consideration or against morality is void. It is similar to another well known maxim, ex turpi causa non oritur actio, which means that no action arises from an immoral cause or base consideration. Contracts founded on a consideration which is illegal or unlawful are void. Yet another maxim related to this principle is ex dolo malo non oritur actio, which means that an action does not arise from a fraud. de minimis non curat lex. The law cares not about mere trifles. This maxim is invoked to dismiss any frivolous litigation. Delegatus non potest delegare, which means that an agent cannot delegate his authority. A principal, except by his own assent, is not bound by the acts or contracts of subagents unless they be of necessity or in accordance with the usual custom of trade. Ignorantia facti excusat, ignorantia juris neminem excusat. Ignorance of fact excuses, ignorance of law excuses no one. This principle is applicable only to the general laws of the country, and no person can take as a defense that he or she is not aware of the general principles of law of the land. It cannot be any kind of defense. In pari delicto potior est conditio possidentis. In case of an equal guilt, the condition of the possessor is the better. For instance, where a marine policy is void ab initio, that is from the beginning, from a cause not amounting to any fraud or breach of law on the part of the assured, the insurer is bound to return the premium paid. Yet, when such policy is void by reason of fraud on the assured's part, the latter cannot then reclaim the premium and the rule applies. Interest reipublicae ut sit finis litium. It is to the advantage of the state that there should be a limit to lawsuits. The statutes of limitations have been passed with a view to limit the time within which actions may be brought. But for these statutes, a plaintiff might delay bringing his action until the defendant had lost, by casualty or otherwise, the evidence on which his case rested. Similarly, this maxim also constitutes one of the bases of the common law principle of res judicata. Necessitas non habet legem. Necessity has no law. This is related to another maxim, necessitas vincit legem, which means necessity defeats the law. It can be invoked to claim immunity from criminal liability also. Nemo dat quod non habet. No one can give what he has not. No one can, other than by sale in market, overt, confer upon another a better title than he himself has. A great exception to this principle occurs in the case of negotiable securities, which by custom are transferable like cash by delivery. Nemo debet bis vexari pro una et idem causa. No one ought to be tried twice or twice put to trouble for one and the same cause. It is a well established principle of criminal law that where a man is indicted for an offence and acquitted, he cannot afterwards be again indicted for the same offence, if he might have been convicted at the onset by proof of the facts contained in the second indictment. This maxim justifies the protection against double jeopardy as contained in Article 20, Clause 2 of the Constitution of India. Nociter associs. It may be known or explained from its associates, that is, the meaning may often be gathered from the context. This refers to the construction of words and clauses in contracts and written instructions. The principle of agesdum generis, which means of the same kind, is an offshoot of the same maxim. Pendente lite nihil innovator. While a long suit is pending, nothing must be altered. This maxim is recognized in India under the Transfer of Property Act 1882 in the form of doctrine of lis pendens. Similarly, it is understood that when the matter is sub judice, no changes to the subject matter of litigation can be effected without the permission of the court. This principle or effect is limited to the rights of the parties in that particular suit. Potior est conditio possidentis. The condition of one in possession is more preferable. The old English adage that possession is 9/10 of law, now very qualified in its truth and application, probably had its origin in this maxim. Qui facit per alium facit per se. He who acts through another acts through himself. This maxim is related to the liability of the principal who acts through his agents. A contract made by an agent is looked upon in law as the contract of the principal, so agents need not be sui juris, and infants, married women and others are competent to act as such. The agent must, however, act within the scope of his authority. Qui prior est tempore, potior est jure. He who is first in point of time is preferred in law. The rule stated in this maxim applies as between finders of treasure trove, derelicts and such like. Here several persons have interests in the same property and equal equities in every point except time, as in the case of a third mortgagee who had no notice of a second mortgage when making his advance. Here both mortgagees have equal equities, but the second mortgagee, being the first in point of time, has the prior right. Re ipsa loquitur. The thing speaks for itself without proof. It is frequently quoted in actions for damages for negligence. Re judicata pro veritate accipiata. A point judicially decided is taken to be correct. It is related to the doctrine of precedent. This is conclusive so far as courts of inferior jurisdiction are concerned until the judgment is reversed. Respondent superior. The meaning of this maxim is that let the principal answer. One authorizing an unlawful act to be done by his servant is himself answerable. The maxim does not apply as against the crown or the state. This is the basis of vicarious liability. Sic utere tuo ut alienum non ledas. The meaning of this maxim is that so enjoy your own rights as not to injure those of another. Where the natural course of a stream is over the surface of lands belonging to different proprietors, no proprietor above can diminish the quantity or injure the quality of the water which descends, nor can a proprietor below throw back the water without licenses from the proprietors above. Suppressio veri suggestio est falsi. The meaning is, withholding the truth suggests falsehood. This maxim is the basis for the definition of fraud as a vitiating element in declaring certain contracts as voidable under the Indian contract law. Testis Nemo in sua causa esse potest. No one can be a witness on his own behalf. This rule applies to criminal charges and its effect is continually being modified by legislation. The opinion of those best qualified to judge differs whether or not all accused persons should not be competent witnesses. Ubi ius ibi remedium. The meaning is, there is no wrong without a remedy, or where there is a legal right, there is a legal remedy. An action will lie for an injury although no actual damage be sustained, as in the famous case of Ashby versus White, where it was decided that an action lay against a returning officer for refusing to admit the vote of a duly qualified elector, although the persons for whom he tendered his votes were elected. There may be a damnum sine injuria, that is, loss without a wrongful act, for which no action will lie. Thus, no action will lie against one's neighbor who builds on his own land a mill whereby the profits of one's own mill built on the adjoining property are diminished, although in the case put considerable loss may result. This maxim formed the root of all equitable decisions and was the basis upon which the Court of Chancery in England originally acted when interfering with courts of law or in supplying remedies for those wrongs which the latter failed to redress. Vigilantibus et non dormantibus succurrent jura or aquitas subvenit. The meaning of this maxim relating to law of limitation is that laws come to the help of the vigilant, not of the sleepy. It is also written as equity assists the vigilant. It is one of the justifications for stipulating limitation period for exercising the rights. Volenti non fit injuria. No injury can be done to a willing person. If a person voluntarily consents to an injury, he must bear the loss. For example, in England, once it was believed that a woman cannot herself support an action for seduction to which she is a consenting party. Her parent or employer, however, may do so and is entitled to damages for loss of her service, the seduction in which case being the cause. Now, let us understand equity maxims or principles. In England, until the late 19th century, there existed dual system of courts called common law courts and equity courts. The equity courts applied the principles of justice, equity and good conscience while deciding cases, and they did not follow strictly the provisions of law. In the process, they developed many maxims or principles which in modern times are followed by all the courts throughout the world. Let us discuss some of the well known equity maxims hereunder. The equitable maxims provide a set of general principles which can be said to have influenced the development of equity. Equality is equity. Equity, where possible, always favors a tenancy in common as opposed to a joint tenancy. Equity acts in personam, that is, against the person. Judgments of courts of law were always enforced in rem, that is, against the whole world, but the decrees of the court of chancery could always be enforced in personam by attachment. This may be considered as the basis of the maxim that a stranger to the contract cannot be sued. Equity imputes an intention to fulfill an obligation. If the thing actually done might have been done with an intention to fulfill an obligation, the equitable doctrines of satisfaction and performance have recourse to this maxim, and the principle upon which they are founded is the one therein contained. Equity never wants a trustee. Where a valid trust exists, equity will impose on the person in whom the legal estate is vested the duty and obligation of carrying out such trust. Equity regards the spirit and not the letter. Equity looks at the intention of the parties and not at the actual words employed in any transaction. Equity always regarded a mortgage as an instrument to secure the repayment of money and allowed the mortgagor to redeem at any time, but at common law, unless the mortgagor paid back the money by the day named in the mortgage deed, his right of redemption was gone. This maxim is generally invoked in case of penalties and liquidated damages for breach of a contract. He who comes into equity must come with clean hands. For example, an infant, although not generally liable on his contracts, cannot make use of his own fraudulent acts as a means whereby to benefit himself. He who seeks equity must do equity. It is in pursuance of this maxim that the right of the wife's equity to a settlement is enforced. Apart from the above, there are other equity maxims like delay defeats equity. Equity will not permit a statute to be used as an instrument of fraud. Equity regards as done that which ought to be done, and equity will not suffer a wrong to be without a remedy, which will help the students in understanding the application of these principles in legal profession. Conclusion. This lesson has introduced the concepts of maxims to the law students. These maxims, legal as well as equity maxims, will certainly improve the capacity of the students in understanding the nuances of law and their application in legal profession. We also understood the importance of these maxims and the advantage of learning the same. Dear students, I hope that you have found this lesson interesting. Let us meet in the next lesson. Thank you.